Hello and welcome to Lunch and Law, Governors Gone Wild. Lunch and Law is a series that we do here at NCLA, and we talk about important topics. And is there a topic that is more important than the miscreants that have occupied the state houses and got up to no good in the last 12 to 18 months? I argue no, there's nothing more important. We're going to get started with the show in just a minute, but we wanted to lead off by announcing the winner of this year's King George III Prize for the worst violation of civil liberties by a state official. Now, before I tell you who won, let me just lay it out for you. There were about 20 state officials who entered in, we entered for them. They didn't actually volunteer for this ignominious prize. But they should have. They should have the humility, but they didn't. And of the 20 or so, 18 of those were state governors, no surprise. And everybody from Andrew Cuomo to Gretchen Whitmer, Gavin Newsom. There were two officials that weren't actually state governors, the Laramie County Planning Commission and Xavier Becerra, the Attorney General of California. Now, early on, there were some obvious reasons why some of these governors were included. And honestly, all of them could have won. That's how bad things got last year. Tom Wolf, Pennsylvania, he was an early contender because he ignored a concurrent resolution of the state legislature that tried to take back the power he'd arrogated to himself. But he actually eventually ended up losing to Andrew Cuomo early in the rounds. Gavin Newsom, everybody knows about his sort of little trip to French Laundry. And the thing that made that so terrible was that he was so busy restricting the freedoms and civil liberties of the citizens of California. He actually made it all the way to the finals. Gretchen Whitmer almost beat Gavin Newsom to get into that final. And Charlie Baker is somebody that you really can't ignore for a variety of reasons, not the least of which is, again, the arrogation of tremendous amounts of power by a state official. But in the end, it came down to two governors who everybody agreed, based on the voting and online comments, Andrew Cuomo of New York and Gavin Newsom of California. And as between the two of them, the winner of this year's prize, the Georgie, that's what we're calling the King George III Prize. The Georgie goes to Andrew Cuomo of New York. No surprise here. Not just the shenanigans with the nursing homes and then trying to cover it up, but just the belief that he could micromanage the lives of New Yorkers during a pandemic. Never let a good crisis go to waste. That could have been his motto last year. And honestly, the shenanigans that he got up to, that he's been accused of, some of the inappropriate behavior, we won't talk about that specifically, except to point out that it's exactly the kind of thing that someone does when they believe that the law does not apply to them, when they believe that they are above the law, that they're more important, and that really it's all about them. And wouldn't somebody like that be working on a book deal and have his staff working on a book deal that is going to bring him money and fame? Meanwhile, the lives of New Yorkers, it was bad enough that we had a pandemic. It was bad enough that we had COVID. But Andrew Cuomo really earned his Georgie this year. And we at NCLA are proud to be the ones to tag him with, again, this ignominious prize. And I'm not sure how we're going to deliver it to him. Maybe in a dump truck full of something that smells not particularly savory. We'll see. But I hope you've enjoyed this little peek into our King George III Prize. We're going to do this every year. We also actually do a federal level prize. And so we award a federal official as well. But this is Governors Gone Wild. So just wanted to tell you, thanks, Andrew Cuomo, for being the worst abuser of civil liberties in 2020. All right. Well, now I'm going to hand it off to Mark Chenoweth. He's the executive director and general counsel at NCLA. Mark, take it away, my friend.
Thank you very much, Clegg, and thank you for running the King George III contest for NCLA this year. I think it was a lot of fun. And unfortunately, I think a lot of these governors appear to be trying to get in front of the line for the 2021 prize. We're going to have a lot of contenders again, I'm sorry to say. But this was Andrew Cuomo is the winner for 2020, and deservedly so. We have several of NCLA's litigators here today to talk about what's going on with the governor's run wild now. So what are they up to now? And we have a senior litigator, Mike DeGrandis, senior litigation counsel for NCLA. We also have Harriet Hageman, senior litigation counsel for NCLA. And then we have litigation counsel Caleb Kruckenberg, Jared McClain, and Jenin Younes, who will all be telling you about one or more of the governors who have been violating civil liberties during the pandemic. But first, we wanted to start with our own former candidate for governor, Harriet Hageman, who ran for governor of Wyoming in the Republican primary in 2018, and has a unique perspective for that reason on the sort of power that governors wield and how they should superintend that power, or how they should maybe control themselves a little bit more than the folks who are going to be hearing more about today have done. So, Harriet, would you like to lead us off with a little discussion about your perspective on the power of governors?
Well, thank you, Mark, and thank you, Clegg, and it's wonderful to be here again. I also kicked off the Governor's Gone Wild Lunch and Law program 1 year ago, the first one that we had. And I then explained that at the time that I was running for governor, one of the absolute cornerstones of my platform when running for office was the importance of returning to our constitutional foundation and order. And I think what we've seen over the last year has really reinforced my view of the importance of that. During that discussion, I talked about the uniqueness of our founding governmental philosophy, that our constitutional rights are not granted by the government, but they're granted by God. And as such, the government has no authority to take them away. We have many freedoms that we talk about on a regular basis, the freedom of speech, the freedom to assemble, the freedom of association, the freedom to exercise our religion, the right to be free from unreasonable searches and seizures, and the right to due process of law, the right to undertake and engage in the occupation of our choice. Another and critically important foundational and unique aspect of our Constitution and our constitutional republic is the separation of powers, with three branches of government at both the federal and state levels. And we all know what they are. They're the executive branch, the legislative branch, and the judicial branch. I doubt that any of us could have foreseen what has actually transpired over the last year. I know that I have been pretty much surprised on a daily basis to see the kind of power and the power grab that we've seen come from the governors, especially in terms of ignoring so much of our constitutional foundation and our constitutional construct. I never expected to see such a dramatic transformation in terms of the raw exercise of governmental power at the expense of our individual rights. And most specifically, the manner in which many of our governors in this country have sought to exponentially expand their unilateral power while essentially announcing that they do not believe that the Constitution applies in a pandemic. We actually had one of the governors that will be discussed today stated publicly that in terms of the Bill of Rights and complying with the Bill of Rights, that was above his pay grade. One of the most destructive tools used by the governors is how they have taken to define essential versus non-essential businesses or organizations. In California, for example, Governor Newsom declared that marijuana dispensaries were essential, but churches were not. And for those of us who believe that adherence to our constitutional foundations is even more important in an emergency, a pandemic, or other societal disruption, this has truly been a very shocking time. At NCLA, we have been dedicated to pursuing those types of cases that will hopefully lead us back to our constitutional roots and adherence to the rule of law. My colleagues today will be talking about several of the lawsuits that NCLA has been involved with, focusing on both the facts and the legal theories of those cases. At the same time, I think that it is important to understand the real world on the ground costs of our state and federal government's response to the COVID-19, not necessarily the COVID-19 itself, but our government response to it, and the real world impact of ignoring both our constitutional constraints and the importance of a representative making the law through legislation rather than through executive edict. Just to give you a few statistics, between the 6-week period from mid-March to May 8th of 2020, the country had lost 20.6 million jobs, resulting in an unemployment rate of 14.7%, a level not seen since the 1930s. Roughly 50 million K through 12 students were immediately moved to remote learning, approximately 30% of whom had no adequate internet connectivity or a device for remote learning. Many of those without adequate equipment were from our Native American populations. There was a substantial decrease in child immunizations rates for the other type of illnesses that we have conquered in the past. By November 2020, data from Fairfax County, Virginia showed an 83% increase in the Fs that were given to their students. For our most vulnerable children, those with disabilities, Fs were up by 111%. Hispanic students were suffering more than any other racial group, with Fs up by 92%. We had 35% of our students were underperforming in math, and 39% of our students were underperforming in English. By December 2020, and in the 78 largest school districts in the country, at least 240,000 students remained unaccounted for. They had simply disappeared from the system because of remote learning. Over 110,000 restaurants permanently closed as a result of the government's response to the coronavirus, a full 17% of the industry. And the most recent unemployment data from April of this year shows that the states with the most draconian lockdowns also continue to suffer with the highest unemployment rates. And these are some of the states you will hear about today. For example, in April, Pennsylvania's unemployment rate was 7.4%, New Jersey, 7.5%, New York, 8.2%, and California, 8.3%. The fact is that the government's response to coronavirus has been devastating in so many ways. There is, however, some very good news. Just yesterday, it was reported that Governor Newsom has been ordered to pay $1.35 million in damages over the state's draconian lockdown of 3,000 churches during the pandemic, and a permanent injunction has been issued against his orders shuttering churches. So we're moving in the right direction. On that high note, I will turn it over to my colleagues. Thank you.
Why don't we take it from Harriet's incredibly informative and passionate explanation of the situation and move on to the next person that we're going to talk to. And I think that's going to be Mike. Mike DeGrandis.
Thank you, Clegg. So one of the issues I wanted to talk about today is, of course, the status of the Desrosiers versus Baker case. That's the case we brought in Massachusetts. It was heard by Massachusetts' highest court, the Supreme Judicial Court, back in September. We got a decision in December. And while I'd rather just skip over the decision we received in December and talk about what we're doing now, I think it's important that I at least give you a little bit of a summary. So I'll make this quick for me, if not for any other reason. So we had argued that this was not, that the pandemic did not provide for a cause for a Civil Defense Act state of emergency in Massachusetts. The Supreme Judicial Court held otherwise. They said that a pandemic fits within the statute's meaning as a civil defense state of emergency, that Governor Baker's emergency did not violate the separation of powers, that his orders did not violate the separation of powers, and that he did not dispense with the law. Now, when I say dispense with the law, what I mean is that his orders, the Supreme Judicial Court believed that his orders did not, on the one hand, allow some people to enjoy the benefits of their liberty and property interests, while prohibiting other people or limiting other people's enjoyment of the benefits of their liberty and property interests. And there was another facet to this case too, and that was the Supreme Judicial Court disagreed with our position that there were certain, not necessarily all of the orders, but there were certain orders that violated our clients' rights to peaceably assemble. So First Amendment right to peaceably assemble, and 14th Amendment right to due process. Now, the reasoning there is really the basis for our petition for a writ of certiorari in the Supreme Court of the United States. But before I get to that, I think it's important to say that the Supreme Court just proceeded upon just far too lax of a standard in the first place. It premised its decision regarding the constitutional rights of our clients on a decision that was a Supreme Court decision, but one that was superseded. So the first Supreme Court decision, and it's important to note that South Bay United Pentecostal versus Newsom, so a California case in May 2020, was superseded by Diocese of Brooklyn versus Cuomo, a New York case, in November 2020. So the South Bay case said, well, you know what? It's early in the pandemic. We, the Supreme Court, are not virologists. We're not epidemiologists. We are inclined to defer to the political branches when no one really knows what's going on with this pandemic. But that was May. Come November, the Supreme Court said, yeah, that case expired by operation of its own reasoning, because it's no longer a situation where we don't understand the virus. We don't understand the dynamics of the danger. We can't, as a matter of fact, the court said that courts will not shelter in place when the Constitution is under attack. So the idea that courts would give deference to whether it be chief executives, what we're talking about here in this luncheon law, or whether it's even legislatures, there's no reason for courts to defer if what the legislature or governor is doing is unconstitutional. And so that ends up being the sort of premise of where we enter into the United States Supreme Court petition that we filed, hoping that the United States Supreme Court chooses to take up our appeal on those two issues, the issue of free assembly and also substantive due process. I don't know if I should pause there, whether we want to go down a different road before I get into that.
Well, Mike, actually, there are some folks that are watching that have questions about the fact that Governor Baker claimed to only have the power to order certain sectors to remain open and functioning in emergency, but there was no power to shut entire sectors down. Is that or was that part of NCLA's original suit? Was it not? If not, do we consider that?
Well, if I understand the question, it was. I mean, what we were saying was that basically everyone in Massachusetts is similarly situated. So if you want to talk about businesses, for instance, a business license is a business license. And you have certain property interests in that business license, and you have certain liberty interests in pursuing a vocation of your choice. And while it is true that perhaps the Massachusetts legislature could say, we are going to adjust occupancy limitations in businesses across Massachusetts during, while the pandemic is around. The legislature can debate that issue. The legislature can hold hearings and discuss what are the right occupancy limits, and perhaps the legislature can do that. That's not what happened. And so our main point was that this is a process objection. Sure, COVID-19 presented a serious threat to everyone and a mortal threat to some people. That doesn't mean that we should just look the other way and ignore it. No, maybe there is a proper governmental response, but it is not inherent in a governor where a chief executive, the office itself, lacks the tools it needs to effectively protect public health and welfare. And so the governor is kind of left with nothing but just these arbitrary, your business is essential, so you're open. Your business isn't quite as essential, so you'll be open sometimes. Your business, I don't really care. It doesn't seem important to me, like Governor Baker did with the gun shops, and he got scolded for that by a federal judge for closing down gun shops.
All right. Well, that's great. Thanks so much for answering that question. And I'll continue to jump in when I can to maybe add some panel questions. But yeah, I think you can move on to the next portion that you wanted to discuss.
Then just to quickly address what we're doing in Massachusetts, I mentioned that it's a petition for writ of certiorari. We don't have a right to appeal our case to the United States Supreme Court. We have to ask the court to take it up. We cannot argue about the state law and state constitutional issues. There are elements of them that are still relevant, I think, especially to issues of mootness, but maybe that's a discussion for later on. We can only argue those rights that are protected by the United States Constitution. So peaceful assembly, First Amendment, substantive due process, 14th Amendment. Our argument is that the Supreme Judicial Court used an exceedingly lax standard with respect to assembly. The court used an intermediate scrutiny, so not the highest level of scrutiny, which you'd expect for a First Amendment right. Especially since the Supreme Court has been pretty consistent regarding other First Amendment rights, in particular, free exercise clause in COVID-19 cases. And so the standard is so low, it's almost impossible for the governor not to succeed. So we're arguing that no, on the face of the orders, they are not content neutral. You have to apply the highest level of scrutiny to this. And then secondly, with respect to substantive due process, basically, the court decided that as long as a COVID restriction had a rational relationship to public health, it was a-okay. It was the lowest level of scrutiny, and how the court got there is objectionable. And that is, they just simply took substantive due process and put it in the not a fundamental right bucket. In the Supreme Judicial Court's defense, it is true that there is jurisprudence out there that suggests that some rights can be labeled fundamental while others are not. I object to that. I reject that thought. But it is true that there is some jurisprudence out there that suggests that. But that doesn't change the scrutiny that's required when you have a situation where some people are able to pursue their interests, their liberty interests, while others are not able to pursue theirs. And that the governor, the chief executive, is deciding this without any hearings, without any influence from the people, again, because the office itself is ill-suited to get that feedback, any sort of dialogue with the people who are being regulated. This is executive order, it's law by decree, and it's unconstitutional in Massachusetts as far as I'm concerned. The Supreme Judicial Court might disagree with me, but I hope the United States Supreme Court takes up our peaceful assembly and substantive due process issues.
Well, let's leave it there for now. I think we have quite a few Massachusetts folks on the line, so I imagine we might hear from them in the Q&A section. But let's jump over to New York, where Jenin Younes has been tracking some. Well, actually, things were so bad in New York that Jenin moved out of the state. She was living in New York for most of the past year, but we coaxed her down to Virginia or Washington D.C. at least to join us here at NCLA. So, Jenin, give us your firsthand account of what was happening in New York, or at least what's been happening this year. What's Governor Cuomo doing that puts him in contention for the 2021 back-to-back winner of the KG3 prize?
Thank you, Mark. Yeah, so I was living in New York until a few weeks ago, so I got to experience the Governor Cuomo's reign firsthand. I think the highlight was my birthday in January in 25-degree weather outdoors, since the restaurants couldn't be open indoors. So it
was a reign of error instead of a reign of terror in his case.
So the governor's new thing, after he's sort of moved away from shaming people over social distancing and masks and lockdowns, his newest thing is shaming and coercing people into getting vaccines. And actually, New York State is the only state in the nation to have a vaccine passport program, which the governor implemented at the end of March. So the way that the program works is the state of New York, apparently through the governor, entered into a contract with IBM. And IBM developed an app called the Excelsior Pass that you upload, I guess you download it onto your phone. And then it allows you to upload proof that you've been vaccinated or that you've recently tested negative for COVID in order to gain entry into certain venues. So large scale venues like concert halls and sports stadiums can only operate if they utilize this system. And smaller venues like some arts venues, weddings and other catered events can up their capacity if they use the system. So the governor keeps claiming in his various statements that it's voluntary, for both people and businesses. But obviously, you know, if you want to participate in society now, you have to participate in this program.
And this program was passed by the New York legislature and signed into law by the governor?
It was not. And that's one of the most interesting things about it. The governor actually, he had his emergency powers rescinded by the legislature in early March. So he's not supposed to be unilaterally issuing directives anymore. But he announced this program, I think, on March 27th, at the end of March. And he seems to think that he can circumvent the lawmaking process by just calling it a program and calling it voluntary, which is what he's done now. So instead of framing it as having any legal implications, he thinks he can get away with this. And I guess he has so far.
That sounded ominous.
So the program implicates a few constitutional and civil rights. For instance, you have the right to assemble. And what this program does, and the governor is doing, is sort of framing it as a privilege that, you know, if you participate in this program, then you can assemble as you see fit. But if you don't, then, well, sorry, you're out of luck. And that's not really how the First Amendment works. Sorry, this is part of the First Amendment. You know, absent really extreme circumstances, you're supposed to have this right. And people have made the point that, well, you don't necessarily have the right to go into a particular business, bar, restaurant, whatever. But I think a program like this that's sort of wholesale excluding people from society who don't want to get the vaccine or don't want to show their medical records to strangers in order to enter venues can effectively be deprived of this First Amendment right. Another right that's implicated is the Fourth Amendment. You have the right to be free from unreasonable searches and seizures. And the New York Constitution has a similar constitutional provision as well. And there's a fair amount of case law saying that, you know, showing your medical records, being forced to show your medical records is a Fourth Amendment violation. Now, I think what Cuomo might argue, and some people might argue, is this is private businesses doing this. This isn't the government. But the government also can't use private actors to do what it can, and that's sort of what's happening here. I think Cuomo knows that he can't have police outside of establishments going through looking at people's proof of vaccination or lack thereof. So he's using private businesses to basically effectuate his program. So a lot of people have cited a case called Jacobson. It was called Jacobson v. Massachusetts. It was from the early 1900s. And that was a case where the Supreme Court said that a local government could fine people $5 for refusing to get the smallpox vaccine. That's about $150 in today's currency. However, that case is really quite different, and I don't think it allows for what we're seeing here. First of all, the local legislature had passed that law. So that's very different from what's going on here, where this is the governor using his executive authority improperly to implement this program. Second of all, I think it's different to impose a $5 fine, a one-time penalty for refusing to get a vaccine. Whereas here we're talking about people really being unable to participate in society for the foreseeable future. And then there's a difference between the disease and the vaccine. Smallpox is a disease that kills around 30% of people, where the coronavirus has a much, much lower death rate. Smallpox also kills children, kills young people much more, which means it's a very different disease that, so the justification is a little bit, it's not as easy to justify a program like that, I think. And then finally, the vaccine for the coronavirus is only authorized under what's known as the Emergency Use Authorization Statute, a federal statute that allows for expedited approval for in emergencies for medical treatments or vaccines. All of the coronavirus vaccines have only been authorized for use under the statute. And the language of the statute is quite clear that people should not be coerced. It requires free and voluntary consent. People are supposed to be informed of the risks and benefits, alternatives to receiving it. That's really not what's going on here when you have a governor telling people you can't go into Radio City Music Hall unless you get the vaccine. You can't, you can't go to sports events unless you get the vaccine. You might not be able to go to your friend's wedding or your son's graduation party. And so this is really, for all of these reasons, this is an abuse of power similar to what we've been seeing from Cuomo all year.
Yeah, absolutely. And I mean, you and I were talking yesterday, Jenin, about the fact that there are now apparently dogs that are trained to detect COVID. So without weighing in one side or the other, whether the government could use those dogs the way that, for example, it uses drug sniffing dogs, it at least shows that there are methods other than forcing you to turn over your medical records to try to detect whether someone might pose a risk to someone else. Well, we're going to shift from New York over to, I guess, New Jersey, Jared. That's where you've been focusing a lot of your efforts on behalf of NCLA. Tell us what's been going on with Governor Murphy.
Yes, thank you. So Governor Murphy, since the beginning of the pandemic, has issued over 100 executive orders, and I'm going to focus on two of those today, mainly one, but they're sort of tied together. In March of 2020, Governor Murphy issued executive orders 106 and then 128. And the first one was an eviction moratorium. So it prevented any housing providers from evicting tenants for non-payment of rent or really any reason, even if those eviction proceedings predated COVID and they'd already gotten a court order and were ready to have the sheriff show up and evict. All process was stopped and you were forced to require to continue to house any tenants who had been in place before Executive Order 106 issued. And then Governor Murphy also issued Executive Order 128, which nullified and waived provisions of New Jersey's Rent Security Deposit Act, and it also rewrote residential leases. And what it said was, if a residential tenant wants to move their security deposit toward payment of rent, the housing provider has to allow them to do so. And if they don't, they're violating criminal law and subject to imprisonment, fines, no matter what their lease had said, and no matter what the legislatively passed laws had said at that point. And so NCLA's filed two lawsuits against Governor Murphy, one in federal court and one in state court. And we've challenged Executive Order 128 on several grounds. The first is that there's no statutory authorization that allows Governor Murphy to issue an order like this. And when he issued the order, he cited 4 different statutes, and one pertains strictly to healthcare, one pertained to his authority to control the state militia, one pertained to his authority to control the National Guard. And after we sued him, he sort of backed away from those. And now he's relying solely on the Disaster Control Act in New Jersey. And the Disaster Control Act was passed during World War II as a way to help the governor of New Jersey assist the federal government in its war response. And it gives the governor enumerated powers to do about 10 different things. And most of them are stuff like conducting air raid sirens and practice air raid drills and taking over the streets and controlling traffic if there's a bombing, and coordinating municipal governments when the municipal governments aren't capable of responding to the foreign attacks. And then there's a provision at the end that says, and the governor may do anything else that promotes the general welfare or protects private property. And what Governor Murphy has said is, this is an independent source of authority that has nothing to do with the list that came before it. And anything that I, Governor Murphy, decide is within will promote the public welfare, I can now do. And the judiciary has to defer to my decision that it was within the public welfare and that this was the appropriate way to respond to it. So he's basically asking the courts in New Jersey to give him unlimited, unchecked authority to issue any executive order that he deems would promote the public welfare during a time of emergency. And we've argued that that's not a fair reading of the statute, but also that it would create non-delegation and separation of powers problems, because the legislature itself doesn't have the authority to waive statutes, except for waiving habeas corpus in certain circumstances. And so the legislature could not have delegated to the governor the emergency power to waive statutory provisions like the Rent Deposit Act. And we've also argued that it violates the contracts clause of the federal and the state constitutions. And the argument there is pretty simple. Back at the founding, when we were living under the Articles of Confederation, state legislatures were passing a lot of laws that were relieving debtors of bad debts that they made at the expense of their creditors. So the local governments were sort of picking winners and losers and deciding that some people didn't have to pay their debts. And what this did was—
kind of like picking tenants over landlords?
That's exactly right. And what— before we had the contracts clause with the new federal constitution, back in 1789, but it destroyed the credit of the people that the government was trying to help, and it also destroyed the economy because no one was able to get credit. So we put the contracts clause in place to keep state governments from interfering with private contracts and picking winners and losers. And we've argued that's exactly what Governor Murphy did here. He decided that tenants were in a worse situation than landlords, with absolutely no factual evidence or legislative findings, and that he would relieve the tenants of their obligations under the contract, and that all housing providers would have to shoulder that cost themselves. And so we have argument next week in the Superior Court of New Jersey's Appellate Division to sort of press those claims and ask the court to put some constraints on what would otherwise be unlimited power that Governor Murphy's claiming.
Jared, what about the other aspect of what you were just referring to? You said that the language of the statute also refers to anything else that will protect property, but I would think that taking away security deposits does the opposite of protecting property. Seems to me that it removes the incentive for the tenant to keep the property in good condition, and therefore would tend to destroy property.
That's exactly right. And when you look at the Disaster Control Act, it's not only the enumerated power, but the purpose of the act is to help prevent the destruction of property. And that makes sense when you think about it as a law that was designed for when there were bombing raids by the Germans. And so this law was put in place to protect property, and Governor Murphy has now taken it to destroy contracts and to withdraw laws that were themselves put in place to protect property. And we have clients in New Jersey, the Kravitzes, for instance, who had rented their home to 4 students at Rowan University, and the students in May each sent a handwritten note that said, "Move our security deposit toward our rent," and there was nothing the Kravitzes could do about it. And when they vacated, there was $1,800 worth of damage, and the security deposit had been $2,000. So had the Kravitzes still had their security deposit, they would have been able to cover all the damage that the students left. And we've also argued that the governor created the incentive system to allow those students to leave the property undamaged. Maybe they patched the holes themselves. Maybe they cleaned the stains in the carpet. But because there was no longer a security deposit that the Kravitzes had contracted for in place to protect that property, the incentive structure was changed. The students damaged the property and left, and the Kravitzes had to eat the cost themselves.
Yeah. What about Kentucky, Jared? You and our colleague John Vecchione have also been involved, not with original litigation, but with an amicus brief against Governor Beshear in Kentucky. Can you briefly tell us about what's going on with that litigation?
I can. So this is actually the third in a trilogy of cases against Governor Beshear. And last year, during the initial stages of the pandemic, there was some litigation over whether Governor Beshear had the authority to issue a lot of the executive orders that he was issuing, similar to what we brought in New Jersey and Massachusetts. And what the Supreme Court of Kentucky said was, we think that there was a delegation of emergency power by the legislature. We read these statutes to give the governor this authority. and the legislature was in session. It's a part-time legislature, but it was in session. And the only things it did while it was in session was confirm its understanding that the governor was acting lawfully. Now, if the legislature wants to take back that power, it has the authority to do so. And until that happens, the governor can continue to exercise these emergency powers. And so the legislature comes back into session in January and says, we no longer want you, Governor Beshear, to have these emergency powers, and any emergency order you issue can only last for 30 days unless you call the legislature back into session to affirm that you have the right to continue to issue these orders. And Governor Beshear said, I'm going to go ahead and keep issuing orders anyway. I don't think you have the power to take away my emergency powers. And so there is a group of breweries.
Emergency powers must be addictive for these governors. They don't seem to, it doesn't seem to be a habit they can kick very easily.
Yeah, no, that's exactly right. And you'd think that the longer the pandemic went on, the more constrained their powers might be. But it's actually the opposite has happened, because a lot of these legislatures have acquiesced and the courts were nervous to step in and perhaps risk public health because judges aren't public health officials. And so the more power we've allowed these governors to have, the more that's aggregated and the more they keep trying to grab. And so you have Governor Beshear in Kentucky saying the legislature doesn't have the authority to withdraw a prior delegation of power to me. And you have Governor Murphy in New Jersey saying the courts don't have the power to question my judgment about what I can do during an emergency. And that's why we're bringing these cases, and hope that the judiciary will now, 15, 16 months into the pandemic, see that it needs to draw a line in the sand and restore the constitutional order.
Terrific. Caleb, I want to come to you next. I was going to talk about Pennsylvania a little bit, but I want to make sure we have enough time to get to you. So let me throw it over to you. So for our audience's sake, Caleb has been leading the charge, not just for NCLA, but arguably nationwide, against the CDC over the nationwide eviction moratorium that it has put in place. Caleb filed with help from several colleagues who worked over Labor Day weekend last year to put the lawsuit in place against the CDC in the Northern District of Georgia. Several subsequent lawsuits have been filed, some successfully by other organizations, which we think is terrific. A lot of those used some of the same arguments that Caleb put forward in that case filed last September 8th. And Caleb, where does that stand now? Where does the nationwide eviction moratorium stand? And even though this isn't action by governors, it still has a lot of impacts on state law because of the way that it's shut down state courts.
Well, when we were sort of thinking about this discussion today, one of the things that really struck me is that sometimes states do the right thing, or sometimes want to protect the rights of their citizens. And unfortunately, what we saw with the CDC eviction moratorium, that's a situation where states took a very specific stance, and they said, we want to respect the rights of property owners and people who provide housing for other people. And the CDC came in and said, no, we don't think so. We know better than everyone. We know better than states. And we're not going to let you open your courts and have normal processes. And so I think that's really where the CDC eviction order comes in. But to answer your question about where we stand now, unfortunately, as we sit here today, the CDC eviction moratorium is a way of life across the country. And I expect it's going to continue to be until we get finally—
Except 4 states, right?
Well, sort of, yeah. And so we can kind of talk about that. There are a few states where maybe it doesn't apply, to certain individuals. But unfortunately, the CDC has been very aggressive. And until we get a statement from a court saying otherwise, I think the agency is going to keep extending their order. Just to give a little bit of background about what I'm talking about, for those of you who aren't as familiar, back in September, the CDC issued an eviction moratorium order, and it was pretty sudden. They issued it, and they said, for any state that has chosen not to have their own eviction moratorium. So I guess they were sort of looking at New Jersey's lead here and saying, well, we want to do this too. They said, if you don't have your own eviction moratorium, there's now a federal one. And what our moratorium says is that if you have tenants who stop paying rent entirely, and they say it's because of the coronavirus pandemic, because of economic hardship, you are forbidden from using state court process to evict them. You cannot take your house back, no matter how much they don't pay you. And in fact, it is now a federal crime, according to the CDC, to try to use state court processes the way state legislatures wrote the rules. And the CDC, as we've heard today, invoked a statute that was passed in World War II that said to the CDC, to the agency, they have certain emergency powers that they can take to prevent pandemics or disease and infections. And it says specifically they can do things like quarantining livestock or impounding diseased goods or specific actions like that. But there's a part of the statute that says, or other reasonable measures that are necessary. And
I detect a trend.
There might be a trend here. We might have a theme. Of course, the CDC views this to say we can do literally anything we can think of, as long as we can assert that it's for disease control, but we don't have to prove it. As long as we believe it, you have to trust us.
Now, have courts bought into this, Caleb, this idea that there's no limits on the CDC's power?
Well, I think we can sort of chart a course in the courts. As Mark said at the beginning, we filed our lawsuit immediately. We filed in September, and we sought a preliminary injunction in federal court in Atlanta. And unfortunately, our judge, I think partly out of concern about the coronavirus pandemic and certain, in the circumstances we were all facing then, basically gave the CDC a pass. But since then, there have been a number of other cases where judges have said, no, wait a minute, not so fast. And I definitely think we can see a trend as time has gone on and this kind of pretense has worn thinner and thinner. Judges are starting to be concerned. And most recently, there was a decision in Washington, D.C., where a federal judge invalidated the eviction moratorium nationwide. Unfortunately, that case has been stayed by the D.C. Circuit pending an appeal. As it stands now, there are various orders affecting the litigants in some of these other cases, but there's no nationwide order. NCLA has appealed our decision, though, the decision back in October denying the preliminary injunction. And I actually argued that case in front of the 11th Circuit earlier this month. And we're hoping for a decision soon that's going to say once and for all, the CDC can't do this. And I think one thing that came up during the argument really reinforces the theme of what we're all talking about today. One of the judges asked the attorney for the CDC, if in her view of the statute, the CDC could do something like shut down all schools, public and private, forever. The attorney said, after sort of hemming and hawing, she said, yes, we can. We do have that power. And another judge asked, well, what isn't the pandemic getting better? Why should we keep extending the order, or will you extend the order? And the attorney for the CDC said, well, look, it may be getting
very
better.
evasively.
Well, very evasively again, but it may be getting better now, but we need this in the future because we never know what's going to happen. We need this power because you never know.
I don't want to say anything to take away the agency's power or words to that effect.
Exactly. And obviously I'm paraphrasing, but those that's the mindset we're talking about, is that once these agencies have authority like this, or they get away with it,
putative authority, yeah.
Right. Then they want to keep doing it. And look, I mean, the CDC eviction moratorium was supposed to end in December of 2020. It's currently on the books through the end of June, and I think we expect it to be extended again. And I think that is all part of this idea that we have to use an emergency as an excuse to push a political agenda or our particular agenda. And then once we get away with it, we're never going to give that power back. And so that's why I think all of my colleagues here, that's why we're doing this litigation. And that's what we want out of this, is we want the courts to draw the line in the sand and say, no, this is not acceptable. You can't keep using these excuses.
Well, we're going to jump to the Q&A momentarily, but let me just say a couple of words about what's been happening in Pennsylvania. Clegg mentioned at the top of the program that the Governor Wolf was certainly a worthy contender for worst violator of civil liberties among governors in 2020. And one of the reasons for that is because he completely upended the system of government in Pennsylvania, with the help of the state Supreme Court, unfortunately, with, of course, many people that he had appointed on that state Supreme Court. We saw the same thing in Massachusetts, Mike, with Governor Baker having appointed almost that entire court who stood behind him in his violations of civil liberties. So there's a concern and a problem there that might need some attention. But what happened in Pennsylvania was similar to what Jared was talking about in Kentucky. It happened sooner in Pennsylvania, actually. The legislature, there was a lawsuit against the governor saying, hey, you don't have this power. There's a case back a year ago, April 13th of 2020. Friends of Danny DeVito, not that Danny DeVito, v. Wolf. And the Pennsylvania Supreme Court turned away that challenge to the governor's powers and said, in part, that as a counterbalance to the powers granted to the governor, the emergency code provides that the General Assembly, by concurrent resolution, may terminate the emergency. So, much as what has happened in some of these other states, the legislature came into session and they voted to terminate the emergency. Well, the governor didn't like that very much. He didn't want to give up his emergency powers. That concurrent resolution passed on June 9th of last year, so almost a full year ago. It was a bipartisan vote. The state House vote was 121 to 81. That included all Republicans and 12 Democrats in favor. And then the vote in the state Senate was 31 to 19. We're not talking about razor thin margins here. We're talking about overwhelming majorities of the state legislature trying to curb the governor's powers. Again, that was all the Republicans in the state Senate and 2 Democrats in favor of curbing the governor's power. So together, more than 60% of the legislature voted to end the governor's unilateral rule. Notwithstanding that, on July 1, in a case called Wolf v. Scarnati being, I believe, one of the state senators in Pennsylvania, the state Supreme Court held that a vote of both houses of the legislature counts for nothing, that you have to have the governor's signature on a bill to curb the governor's power because it has to go through bicameralism and presentment like any other piece of legislation would. Of course, that completely ignores the fact that the original legislation giving the governor the emergency powers would have been unlawful based on the Supreme Court's reading of that legislation's inability to allow the legislature to check the governor's power. You can't have a legislature give up power that it can't take back. That in itself is unlawful. That in itself, as I say, upends the power of government, because what you had in Pennsylvania was a situation where the governor could do anything he wanted unless and until 2/3 of the legislature were able to overturn his veto. So they had 60%, which is pretty amazing. They didn't have 2/3 of both houses. And so he was able, according to the state Supreme Court, to just completely rule by edict. And the good news is that even though they weren't able to get 2/3 votes in the House and the Senate, the legislators were crafty in Pennsylvania. And they said, well, let's go to the people. Let's put a constitutional amendment on the ballot in Pennsylvania. And so they did that. In fact, they put 2 constitutional amendments on the ballot in Pennsylvania dealing with the emergency. The first one, and I'm just going to share with you what these ballot measures were. The first one said, shall the Pennsylvania Constitution be amended to change existing law and increase the power of the General Assembly to unilaterally terminate or extend a disaster emergency declaration, and the powers of Commonwealth agencies to address the disaster regardless of its severity pursuant to that declaration, through passing a concurrent resolution by a simple majority, thereby removing the existing check and balance of presenting a resolution to the governor for approval or disapproval. Now, you might think when you hear that, gosh, that sort of sounds like a lopsided or one-sided description of what's going on here. It doesn't really talk about the fact that the governor is operating without a check or balance at all. Well, that's because the governor got to write the language of the ballot measure. So that's the part of the ridiculousness here. The second ballot measure that was on the ballot in Pennsylvania just a very short number of like a week or two ago was, shall the Pennsylvania Constitution be amended to change existing law so that a disaster emergency declaration will expire automatically after 21 days, regardless of the severity of the emergency, unless the General Assembly takes action to extend the disaster emergency. The governor may not declare a new disaster emergency to respond to the dangers facing the Commonwealth unless the General Assembly passes a concurrent resolution. The General Assembly enacts new laws for disaster management. So again, a lopsided articulation of what was actually at stake. But the people of Pennsylvania weren't fooled. They had lived under Governor Wolf's arbitrary decrees for long enough. And by a vote of roughly 52% to 48%, both of those constitutional amendments passed in Pennsylvania. And the governor has essentially conceded that they passed and that his powers are being curbed. And so maybe that's a happy story, that at least in Pennsylvania, the people rose up against the governor's arbitrary rule and were able to amend their constitution. Now, that never should have had to happen. The state Supreme Court was absolutely wrong in the decision that it handed down on July 1st of last year. But it's nice to see at least democracy prevailing in the end, and 52%, although that's a scary thin margin, 52% of Pennsylvanians understood that they don't want to live under a monarchical dictatorial rule of a governor acting like a king. So we'll end. It didn't sound very happy, but we'll end on that happy note and jump over to Q&A. And there were a couple of questions. I'm not going to go through these in a consecutive order because there were a couple things that jumped out at me that I wanted to throw to folks first. And one of the questions that was put is, how can these regulatory agencies issue these orders? These aren't laws. How is the CDC in a position to do any of this? Caleb, maybe you want to start with that one, although I imagine other folks might want to jump in with explanations as well.
Well, yeah, they can't. And that's the shorter answer is they're not supposed to. Unfortunately, the courts have kind of let them do it. That is part of our argument. And, you know, the CDC says, well, Congress gave us this power to do literally anything we can think of, and we just thought of it. So here you go. But that's not the way the Constitution works. That's not the way that's not the way federalism works. A state cannot be overruled by a federal administrative agency that's just acting on its own. And also, in the particular context of the CDC, we all have a constitutional right to use the court system and use the courts the way our state courts have been set up. And once we have a right in court, once we have the right to take our own property back, the government can't take it away. It's certainly not an agency like the CDC. Unfortunately, as we've said, at least so far, the CDC's gotten away with it. But I'm optimistic that in the end they won't.
Anyone else have a thought on that question about how the agencies get away with this?
I briefly would comment that I think with so many things related to this, that there was real fear in March and April of last year as to what this pandemic portended. And I think that the courts were reluctant to step in and address what were clearly constitutional violations and constitutional overreach because of the concern about being accused of killing grandma. And the irony of that is, really, that was Andrew Cuomo with the kinds of restrictions that he adopted. I mean, that's really the irony of this. When your first goal is to circumvent the Constitution, I don't think it ever ends well. And I think that's what we're seeing, is we're seeing private property rights destroyed. I've been reading some of the comments in the chat room, people who have lost $50,000 because of the eviction moratorium, losing their property, unable to reclaim it. Circumventing the Constitution is never going to end well. And the courts over the last year have really allowed these governors to do that. And I think in the long run, I guess I'm optimistic like Caleb is. I think there eventually will be a comeuppance. We have suffered for the last year because of it, and we need to really dissect this and understand what happened over the last year so that it never, ever happens again.
Jared, you were going to say something?
Yeah, just to echo what Harriet was saying, it's definitely fear. And the first time a governor of New Jersey exceeded the scope of the like plain text of the Disaster Control Act, fortunately, in that situation, it was to conduct air raid drills without any ongoing emergency. But what the court said was, in the age of the atomic bomb, how can we not give the governor this broad authority to do what he needs to do to keep us safe? And the only legal citation they had for that was an article called Municipal Governments and the H-Bomb. And so, like, it's not new in this country, unfortunately, that once there's some public fear that our political leaders will seize more power. And at NCLA, that's what we're trying to fight back against, and ask the courts to just keep a level head and not give into that fear mongering.
Terrific. Another question that popped up in the chat room is just asking if any of the panelists can venture a guess which challenges to governor executive decrees will ultimately be heard by the Supreme Court. And obviously, Mike, we know you have a hopeful answer about Governor Baker's being heard, because we have a pending cert petition. But do folks have any thoughts about other cases that might make it to the Supreme Court? It seems so far, at least on the shadow docket, that the Supreme Court has been very interested in some of the religious liberty cases, but hasn't, at least to my knowledge, hasn't taken any cases that weren't religious liberty cases. The other cases that have succeeded at the State Court of Appeals level have been gun cases, like gun shops that were closed down, where there was a Second Amendment argument to keep the gun shops open. I know those succeeded in a couple of places. Are any of you aware of other kinds of cases that seem promising for cert review?
I'm not, if I could just jump in there, I don't know that I'm aware of any other cases that are ripe for this, other than ours, of course. But really, because we are pressing the peaceable assembly issue. So you're talking about, free exercise is something that the Supreme Court has taken up time and again through COVID-19, has even sort of evolved in its perspectives of what are legitimate constraints on free exercise issues. But right next to free exercise, right next to that and free speech and all of the other rights enshrined in the First Amendment is a right to peaceably assemble. And I just think that they are so closely related. And as you're saying, since the Second Amendment seems to have gotten attention in some of the courts of appeals, you're talking about others, and again, I hate qualifying some rights as fundamental and others as less than fundamental. But when you have these fundamental rights, I mean, I think at some point, Supreme Court's got to chime in on more than just free exercise.
For sure. Next question is, at some point, can these governors be found criminally responsible? Their abuse of power is so extreme, it seems warranted. That question's from Deanna. Does anybody have a response to Deanna about criminal liability for these governors? I would think Jenin killing grandma ordinarily would be something that there would be criminal penalties attached to.
Yeah, if there was anything, I would say it might be Cuomo's handling of the nursing homes, but I think that's exceedingly unlikely to result in criminal penalties. I would just say, I mean, first of all, it was obviously a bad decision, and his hiding the numbers might almost be the worst, the most egregious aspect of this. But he did make these decisions in March and April when people didn't really know what was going on and were afraid. So I would think that courts are going to be relatively lenient in looking at his conduct there. Again, the lying about the numbers maybe something there. I don't know, Caleb.
Caleb, you have any thoughts on criminal penalties? Jenin and Caleb are our former criminal defense attorneys on our staff. So they have the most experience in this area.
Well, in my experience, it's very easy to be criminally charged with something unless you're in the government. And so I think, the reality is there's not going to be much fallout for the governors, for administrators, and at least for governors, I think hopefully there's fallout from the voters. I think we can express our frustration, but that's really what makes administrative regulations, executive regulations so pernicious and so dangerous, is that it's very hard to hold these people accountable. Yeah. And so we try to sue them. We try to get the courts involved early because there's very little we can do on the back end.
Absolutely. The next question from, I'm guessing at the pronunciation here, Borjan. What is the panel's explanation of the extraordinarily high level of unquestioned compliance by the public for extended period of time since March of last year? We were talking about fear motivating the judges. Is fear what's motivating the compliance from the average Americans, or is it something else? Is it trust in government, overweening trust in government?
I think that's part of it. I think it's the fear. I think that we have become, and I think especially it's locational. I think it also depends upon where you live. As many of you may know, I spend the majority of my time in Wyoming, and you didn't see much compliance. The governor did issue orders, but most people didn't listen to him. And that's just kind of the culture of what we have here. In Washington, D.C., when I returned back there, it was very different and people were very compliant. So I think it's in part where you're located, but I think that there was an enormous effort by the press and by the governors to just literally put the fear of God in all of us and scare everybody into submission. And I think that's another frightening development.
If I could just add one thing, that I completely agree with what Harriet's saying. Just if we take it from the perspective of, for instance, our business clients in Massachusetts, a lot of businesses were unnecessarily burdened. People have gone out of business completely. People lost jobs for extended periods of time. But it's difficult for a business to make the choice to fight these orders, because ultimately they want to reopen, and that you don't necessarily want to attract the attention of the government. And it's difficult to justify sometimes fighting the government when it's just going to cost you money and an attorney. And you can't sue the government for compensation. You can't say, you closed my business for 3 months, now pay me what I would have made for those 3 months. And so at some point, you have to make just a rational calculation. I think there would have been a lot more pushback were that not the case, but the dynamic here also being so shocking. I mean, outside of the business context, I mean, when has any of us ever been restricted from hosting a New Year's Eve party that's going to watch the ball drop on TV because you've got more than 10 people in your house and it's after 9:30 p.m.? I mean, that's never happened before. There's a certain element of shock to this too.
Well, and that brings up another question, Mike, in the Q&A, which is, what was the previous precedent for emergency powers? Weren't there previous rulings on how long, et cetera? But to your point, some of these orders are so draconian that there really hasn't been precedent for them. Governors have not tried to get away with canceling Thanksgiving or Easter twice in the past.
Right. Yeah. And that's one of the unique dynamics here too of assembly claims, and because assembly touches on so many of the governor's orders, of governors plurals orders across the country, you rarely have a distinct assembly claim. Usually the government is trying to regulate your marching or speaking on courthouse steps or just some sort of public interaction where you're also being expressive. You're also enjoying your right to free speech as well. But this is entirely different. And so it's really uncharted territory when my assembly, all I want to do is I just want to host a dinner party of 11 people past 9:30 p.m.
Are you the governor of Michigan? Because if you're the governor of Michigan, it's okay.
That's right, unless you're a governor yourself, in which case you're good to go.
Yeah. Yeah, that sort of hypocrisy, I mean, but that sort of hypocrisy is something that's endemic to these sort of command and control structures, right? We know this from studying the Soviet Union. The rules didn't apply to the leaders of the Soviet Union. They only applied to the serfs, if you will. I know that's the wrong time period for Soviet history, but let's see. What about the failure of the DOJ to pursue civil rights, in particular, thinking about ADA issues that might be associated with masks? Jenin, I know you and I have talked about the fact that some people have an anaphylactic reaction to a vaccine, or there's other medical reasons why they may not be able to get vaccinated. What about that situation?
I just don't see that the DOJ seems to be pretty much on board, and as sort of part of the government, I don't see it wasn't realistic. It didn't happen. I'm not really surprised it didn't happen, to be honest. I think it's up to other entities to challenge these laws.
I think the DOJ did weigh in on some of the religious liberty cases under Attorney General Barr last year. I can't quote you chapter and verse on which cases there were, but I'm not aware of them weighing in. They didn't weigh in our case against Governor Baker in Massachusetts. And I don't think that they've weighed in most of these cases. And obviously they're defending the CDC and in the nationwide eviction moratorium case. And that moratorium was started under President Trump and continued under President Biden. So we have a very bipartisan violation of civil liberties on some of these matters. Another one that we haven't talked about today, because this is at the federal level, is the Biden travel ban, right? So right now, there's an executive order that tries to say, look, if you're an American citizen, you want to come back into the country, you have to have a COVID test. And if you can't show that you don't have COVID from a test, then we're not going to let you back in the country. Well, I'm sorry, I have a right to return to the country. That's a constitutional right. You can't take that away by forcing me at my own expense, or saying, well, you happen to be in a country that doesn't have testing available, so you're just out of luck. There's a real constitutional problem with that sort of thing. But again, you see DOJ defending those under both Trump and Biden, not pushing back. So I don't think DOJ is a place we're going to have to turn. I guess we're going to have to rely on public interest law firms like the New Civil Liberties Alliance to be morally and logically consistent from administration to administration.
And some of the civil liberties organizations you would have expected to do something like the ACLU really didn't.
Yeah, the ACLU has been AOL, or AWOL, I mean. Next question we have is about regulatory enforcement in New York. Eric says that if someone comes into a store unmasked, the business will be fined no matter if they supported the action or not. The government clipboard police can also issue fines at any time. They don't have to catch the business in the act, and these fines are large, which has resulted in thousands of businesses and their employees acting as de facto COVID enforcers. This has been extremely effective in silencing dissent and keeping businesses closed. It has muted the natural checks from the community. This seems like it will only get worse if it's not addressed. Is there any legal relief in this area? And I think we see the same things what I was just talking about with the forcing people to have COVID tests before they come back in the country. The federal government is trying to enforce that through the airlines, right? They're trying to get the private businesses to do their dirty work. And I saw someone in the chat had said it's like the government has put on private industries the gloves of private industry and then choked you and said, no, it's not us, it's the gloves. Which I thought was a pretty clever analogy. But what about that? Is there any legal relief in sight from the clipboard police who seem to be using, and Jeanine, maybe we'll come back to you since the person mentioned New York, but is there any way to keep the clipboard police from using private business to enforce things like the mask mandates or you were talking about the vaccine passport issue?
I mean, I would think that there would be a way to do this. It would have to be litigated. I think part of the problem is that the businesses don't really have that much of an incentive to fight back against this. It's probably easier for them just to ask their customers to wear masks than to say, you know what, we don't want to participate in this. Especially since most people in New York having lived there, are like really on board with the masks. So I think you just have an atmosphere where it's although I think there are theoretically good legal arguments, and for instance, there are people who can't wear masks or it's very uncomfortable for them because of disabilities, or autistic children have a lot of trouble with it, or children with other disabilities. Even though there probably are legal arguments to be made that at least certain people shouldn't be forced to wear them, I think there's a motivational problem in terms of people actually litigating this.
Right. Well, there's one more question in the queue, but I think we're going to run out of time, and I wanted to give everybody, at least 30, 45 seconds for a final thought. So let me go through in the order that we started with. Harriet, we'll start with you. If you just have a final thought on some of the questions that we've been posed today.
I appreciate the comments. I've been watching them in the chat room, and I think that there are quite a few like-minded people on this Zoom meeting. I'm proud of NCLA for being willing to fight these battles. We've definitely had some frustrations in that process, but I think we've exposed some things that are very, very important. And hopefully from here, we're going to be able to build a more robust set of arguments in terms of challenging government overreach and at the administrative level. And again, I'll just say it. I think one of the themes has to be attempting to circumvent the Constitution is never going to end well for any of us. And we need to take that message forward and make sure that our governors and our leaders and our politicians recognize that the very foundation of who and what we are as a society is dependent upon enforcing and protecting our constitutional rights.
Mike, quick thought?
I think it's an opportunity that we see here, just what happens when executive actors, so the administrative state, whether it be an individual or an agency, has the opportunity to exercise legislative authority, executive authority, judicial authority, the type of issues that NCLA addresses day in and day out prior to the pandemic, where it may have been difficult for some people to appreciate that the threat the administrative state poses is profound. It's not just about telling ExxonMobil, don't dump a barrel of gasoline in the creek behind my house. It affects each and every one of us every single day. And this was certainly administrative state on extreme steroids. But I hope that one thing we get out of this, we Americans, just society, begins to understand and appreciate the importance of separation of powers, and just holding executive department actors accountable, and their legislators too, because far too many legislators have been happy to have the executive, either governors or administrative agencies, do their dirty work for them, and I think that's too bad as well.
Yeah, wake up, America, Mike says. There might be a silver lining here. Jenin?
I'll end on a personal note. I was, for the last year, very disturbed by the public acquiescence to what was going on. I saw overreach, and that was why I came to work for NCLA, because I saw that they were the only organization, or one of the few organizations actually doing something to combat this.
Well, there's a silver lining for us. It's great to have you on board.
Thank you.
Jared?
Yeah, just briefly, we've talked about the separation of powers and governors and agencies using legislative power, but there's practical consequences to that. And in New Jersey, the governor has issued these orders that hurt housing providers, and the legislature has separately responded to help some housing providers, but not others. So the small housing providers, like the ones we represent that only have 1 or 2 units, they're not helped by the legislation. And when these laws are enacted through executive fiat rather than the legislative process, there's no holistic approach, and the one hand isn't talking to the other, and you get worse outcomes that don't consider all the constituencies.
Absolutely. Caleb?
Well, I just want to sort of close by talking about our clients. And, it's something that came up in a conversation just a minute ago. It takes a certain level of bravery, I think, to file a lawsuit against the CDC or against Governor Baker, or really take a stand for what you believe in when there's no money involved. You're not going to get a judgment. And we couldn't do this without people that are brave and willing to take a stand and get their names out there. And so, I want to stress that. And if you want to learn about some of our clients and their personal struggles, go to our website and you can hear from them. And I think that's just kind of where I want to leave it.
Yeah, absolutely. Our clients are our heroes. That's why we have pictures of them adorning our office. So we walk by every day and we see the people who we serve and the people who are brave enough to stand up and fight against violations of civil liberties, because Caleb's absolutely right. We couldn't do this without them. I did see a question in the Q&A come in. What can we do people power wise to help NCLA? So let me close on this note. By all means, go to the website, nclalegal.org. If you aren't already signed up for our newsletter or some of our other publications, if you're not already listening to our podcast, if you're not already following us on Twitter, do those things. We're on lots of different channels, Instagram, Facebook, etc. And we're happy to keep you apprised of all the different cases that we have going, more than 3 dozen going on right now, and trying to push back against these governors. We've just added 3 new attorneys, and Jenin is one. We've added 2 others here in the last couple of months, and we're going out to a hat in hand to raise money to pay for the growth that NCLA is undergoing right now as well. So if you're inclined to donate to NCLA, there's a way to do that on the website as well. And we certainly appreciate all of our supporters and followers, and there are ways, both financial and non-financial, to support what we're doing. And so thank you for tuning in today to the Lunch and Law. I hope it was informative and entertaining for you, and we look forward to having you on future Lunch and Laws and other programs that NCLA produces. Thank you very much. Have a great day.